Hey everybody, it's Christopher Small, the owner of CMS Law Firm. We do estate planning, we do probate, we do it well. Today, I want to talk to you about whether to hold real estate as joint tenants or as tenants in common. Before I do that, I want to remind you, if you have questions about this or anything else related to estate planning or probate, please reach out to us. You can talk to us over the phone for free by going to cmslawfirm.com. Okay. This was a listener question that I got, I think, on YouTube. If you're listening to this and you ever have any questions, feel free to reach out to me in any way that you can. I'm happy to answer your questions here. That's sort of the point. Give you a little knowledge, help you out, and basically try to convince you to talk to an attorney before you do anything crazy. All right? So, joint tenants versus tenants in common. Pretty common question. There's a lot of I guess, confusion about these two terms. They sound very, very similar. You would think that they would just make up different names to just state clearly what each of those things are. So real quick, to give a little bit of background, joint tenants is, the long form is typically joint tenants with rights of survivorship. That's the key. If you hold something, a piece of property with someone as joint tenants with rights of survivorship, that means typically when one person dies, their interest in the property goes to the other property holder or owner. Whether you have a will, whether you have whatever, when you die, if you have a joint tenants with rights of survivorship, that property is going to go to the other property owner, okay? The other way to do it is called joint or tenants in common, is what it's really called, tenants in common. And what tenancy in common, tenants in common, is basically the opposite. If you own property with someone else and you die, that property interest is distributed according to the laws of intestate succession or testate succession if you have a will. So if your will directs that property goes to someone, that's where it goes. If you don't have a will, then your property goes is distributed according to the statutes of the state that you live in. And that's the big difference. Typically, in Washington State at least, if you buy property with someone, that property is going to be titled as tenants in common, where each person retains their own share of ownership, and when they die, it goes wherever you want it to go. This is important to know if you want your property to go to the person that you are owning the property with, and if you do not want it to go to the person that you want it to go, or that person. If you are married and you hold property as joint tenants, or as tenants in common, then it's pretty simple for that property to transfer to the spouse. Typically, you don't have to do much. There's something called a lack of probate affidavit that you can file later if the house needs to be sold or transferred in some other way. Not that big of a deal. If you own property with someone that you are not related to or someone that you are not married to, then it's going to be really important to either give that person the property in your will, or do something called a transfer on death deed that you can record that says, when I die, I want the property to go here. Probably going to be the smarter way to do it because you can then avoid probate. All right. So when you are creating or when you're purchasing property with someone, the way that the property is titled is important. Like I said, generally the default is going to be tenants in common. If you want it to be joint tenants with rights of survivorship, I believe you can ask the title company, or you can ask your mortgage person or whoever is preparing the deed for you to do that. And they often will do it for you. They'll put the specific language that's required to create joint tenants with rights of survivorship. They'll put that in there if you ask them. But before you do that, please make sure that you are doing the right thing. You are doing the thing that will accomplish the goals that you have, and do that by speaking with a lawyer that knows what they are doing. All right, that's it. So that's the difference. What you actually do, how you have that title, is going to depend on your goals. It's going to depend on who you are holding the property with. It's going to depend on a whole bunch of other different factors. So to say what you should do or shouldn't do is kind of inappropriate. It doesn't really match the question, because different goals are going to be wanting you or forcing you or suggesting you to do different things. All right, that is it. As always, if you like this video, hit the like button. If you're someplace you can subscribe or leave a comment or leave a review, please do so. It will help other people find the show. If you have a question, let me know. I'm happy to answer it. And if you want to talk more about your own estate planning or probate things, then you can do that by going to cmslawfirm.com. Okay, that's it. As always, I am Christopher Small. I am the owner of CMS Law Firm. We do estate planning. We do probate. We do it well. Thank you for your time. Thank you for your attention. I appreciate you, and I'll talk to you again soon. See ya.